Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues. Please subscribe to our channel. One of the classic family law issues has to deal with abuse in the home. Abuse that sometimes relates to domestic violence charges. If you're charged with domestic violence, how are you going to defend that? How are you going to get that charge dismissed? Well, there's a couple pieces of advice I can give you. Number one, you got to look at the relationship. Is the relationship that you were involved in, is that relationship sustainable? If the domestic relationship is between husband and wife, then the question becomes, are they getting divorced? Are they staying married? How's it going to work? If the couple has decided they want to work on their marriage, odds are having that domestic violence looming in the background is probably not the most healthy thing for the relationship. You'll see in a lot of cases where there may be a charge where the wife will decide, you know what, I want to save my marriage. I don't want to prosecute my husband. So she's going to decide she doesn't want to appear. She's not testifying against him. She does not want to participate in court proceedings against her husband. Well, if that happens, that case is probably going to be dismissed. It is true that in a criminal case, it's not one person against another. It's the people in the state of Michigan versus the other, which means it's not the wife's case. So if she doesn't show up, does it necessarily have to get dismissed? And the answer is no. The people can go forward with the case anyway. The problem is, without a complaining witness, their case is going to fall apart like a cheap suit. So in that scenario, what you have is the wife saying to the prosecutor, I don't want this case. The prosecutor saying, well, we're doing it anyway. And then the prosecutor has to start their case. And they get up there before the jury and they bang on the table. They say, this is a terrible case of abuse, and our evidence is going to show that so-and-so was the victim of abuse at the hands of this defendant. And then the defense stands up and says, I'm going to reserve my opening statement until after he's done. And then you know what happens? The judge says, okay, Mr. Prosecutor, call your first witness. Who are they going to call? If the victim doesn't show up, they got no case. They can call the police officer, I suppose. He can testify that, oh yes, I came and everybody was upset and everything. But then when the defense attorney stands up and says, so there was a victim here? Yeah. Well, where is she? Is she in the courtroom? Can you point her out? No. You care more about the case than the victim? Well, I don't know. You get my point. It starts to fall apart. So in a situation where one of the spouses, it's not really something they want to go forward with, that's one way to get it dismissed. Another way to get it dismissed, I think, is, you know, if someone's going to testify against you, you're going to need to have appropriate witnesses who will basically refute the testimony of the one who's testifying against you. So what does that mean? Maybe there's video cameras like Ring or something else, some security camera that caught the event. Maybe there were neighbors who saw it. Maybe you want to cross-examine the person on the theory that if this happened, how come you didn't call the police immediately? Why are there no photos? You know, in other words, every case is different, but there are ways to attack the case itself. So the best way is to have a no-show. But if there isn't a no-show possibility, then you've got to attack the evidence. And of course, your lawyer is going to analyze that evidence and determine a strategy to approach it, pierce it, and render it useless against you. If you have any questions, reach out. We'll be glad to help you out.